want to get this over as quickly and efficiently as possible and have the family be allowed to move on to healing if they can. One of the biggest issues that I encounter and that causes family disputes in trusts and estates is communication. Communication is a good way to avoid disputes, because if people are not getting information, then very often they will suspect the worst. And it's made even more intense by the intra-family dynamics. So each family brings to the table a whole set of ideas about each other, baggage from the past, and that can magnify what otherwise would just be a communication problem into something much larger. And oftentimes, a trustee or an executor who isn't doing anything wrong with the trust or estate is suspected of doing things wrong because they're just not communicating with their family. And their family gets all these ideas and it gets blown out of proportion. And this is why I encourage fiduciaries to communicate with beneficiaries, because you can stop a lot of problems right in their tracks by just keeping people who have the right to information informed. One big rule of thumb for executors and trustees to follow is keeping in mind that while they are in control, they don't get to call all of the shots independently. They have to keep in mind that the beneficiaries are who they are a fiduciary for. So they owe the highest obligation that exists in the law to the beneficiaries. So not only to keep them informed, but also to make decisions regarding the trust or estate with them in mind, because they are the objects of the office that the executor or trustee is in. So they have to make decisions keeping in mind the best interests of the trust or estate beneficiaries. So it's sometimes easy for an executor or trustee to just not consider anyone else and think, well, I know what I'm doing, and I think this is in the best interests of the beneficiaries, but in fact, they're not keeping the beneficiaries in the loop. They're not actually considering what the beneficiaries want or don't want, and they need to do that, and that is a line that I see a lot when it comes to my desk. There's not a specific event or point in time where you know that this is going to have to escalate. I always give every opportunity to do the right thing. So I know it when I see it, but when, for example, the fiduciary just shuts down and stops communicating, that's a big one. When you've asked and asked and asked for information that the beneficiaries are entitled to, and it just hasn't been given. That's another line where, okay, we're going to have to take this to court and have the court help them to do the right thing because they wouldn't do it themselves. But personally in my practice, I am not, believe it or not, in favor of litigation. I try to keep it from litigation because litigation is a clunky and expensive method of resolving problems, and it's much easier to control the landing and discuss as adults and again have them do the right thing without going to court. However, sometimes you have to, because sometimes people won't do the right thing without having a court tell them to do that. Again, I know it when I see it. I try to avoid it, but obviously it's my living to, do disputes in the courts and have the court help whoever is not doing the right thing to do the right thing. The reason you hire a lawyer is to have a disinterested party who doesn't have the emotions that the family will have in situations like this, and emotions run very high and very deep in these trust and estate disputes. It's similar to a divorce, except in a divorce, it's you ruined my life, and in a trust or estate situation, it's you ripped the head off my Barbie when I was 7 and I'm still mad at you about that. So the emotions are very often long-standing, very deep, rooted in history that is decades long in the family. And it's my job to help keep people focused on resolution, no matter how that looks. And again, this is why you hire a lawyer, is because the family is, by the time it gets to me, too emotional to handle this like rational adults. So it's my job, and I tell clients this all the time, let me worry about this now, don't you worry about this. I am a paid worrier. So try to keep your mind off this, and of course, that's mostly impossible, but my job is mostly as a counselor with a lowercase c than a counselor with a capital C. It's managing family dynamics, and it's shepherding my clients through the dispute and trying to get to a resolution at the end. And I always tell clients, the family, if it's going to heal from this dispute at all, can't start to heal until this dispute is over. So we want to get this over as quickly and efficiently as possible and have the family be allowed to move on to healing if they can. The concept of fairness is very prevalent in my practice because families have very subjective ideas about what is fair. So, for example, one thing that comes up a lot is, why was he made executor? I'm the oldest. I should be the executor. Why did this youngest sibling get made executor? That's not fair. And again, this is a very subjective concept of fairness, and this is why very often in my initial intake call, I'll ask where everybody in the family is in the birth order, because oldest siblings have their own baggage, youngest siblings have their own baggage, the middle child has their own issues and perspectives, and all of that informs the concept of fairness. And I have to have the conversation very often with clients about, I recognize that you don't think this is fair, but nothing about this is outside the law or actionable. And again, we get back to me being very much a family counselor as well as a legal counselor, because the law has a very different idea about what fairness is than families do.